I'm Jack Beatson. I'm here as a poor substitute for Johnny Vida, but I'll do my best. I'm not as tall as him or as handsome as him or as knowledgeable as him, but that's who you've got. I left the English Court of Appeal at the beginning of last year, and I'm now one of the arbitrators at 24 Lincoln's Inn Fields, that's Essex Court Chambers, and I have roles in courts and centres in Kazakhstan and the Cayman Islands and take appointments. I'm going to moderate and be a timekeeper in this session on arbitral decision-making. Robert von Mehren, formerly of the firm, Donald's firm, once said that the arbitrator is the sine qua non of the process. The process cannot rise above the quality of the arbitrator. And the key to the process, in a way, is the decision-making process. So it's very important. We have a stellar panel of speakers, two of whom are from a common law tradition, Donovan and Juliet Blanch, and two of whom are from a civil law tradition, Ricardo and Filipa. They've identified 5 topics. Each will be briefly introduced by one of them to open up a conversation between the panelists and then with you. With 5 topics, well, we'll pretend we started on time. With 5 topics, we stop at 11. I don't like to keep people from their coffee. It's going to be tight. So I've got authority from all of them to be absolutely brutal, but then I'll also be brutal with all of you. There is a wealth of experience here. The first topic is about how different legal cultures and experience influence decision-making. The second is economic and other behavioral incentives that arbitrators might be subject to. Then the appointment process in investment arbitration, the repeat appointment issue. The fourth topic is deliberations. How do they occur? What happens when an arbitrator refuses to engage collegially? And the last topic is what the practice should be with respect to dissenting opinions. So without more ado, we'll start with the first one. Juliet Blanch is going to open the first one, and then Filipa and Donald are going to open the conversation, and we must try and keep it as a conversation.
Thank you. I'm only leaning over to look at the question to remind myself of what it actually says. But my question is, how might different legal cultures and experience influence decision-making? Because it's only a few minutes I have, I am going to talk in stereotypes, so please forgive me for that. The topic is actually far more nuanced. The first point is we need to distinguish between the process to get to the decision and the actual decision. Now, what I mean by that, and I'm going to give an example, is if I'm driving with my husband and we get lost, I will straight away say, let's stop and ask for directions, for help. My husband will absolutely say, no way, I'm not asking for help from anybody, I'm going to find it. Now, we will get to the right place, either by me asking questions or by him spending hours and hours and hours driving around and around till we finally find it. The decision at the end, the result, is the same. The process of getting there, I would suggest my way is far quicker. So I want to look at actually the decision that's reached. So what does and what does not have an impact on that? One of the topics of this conference is common law versus civil law. Now, I think that does make a difference in the journey to getting to the decision. I do not think it makes a difference to the actual decision reached, whichever legal background you're from. Part of the reason I say that is pretty much any experienced international arbitration lawyer is accustomed to both legal systems, will understand the theories and the procedures behind both legal systems. I think there are far more interesting issues which impact on the actual decision reached. Firstly, unconscious bias. We talk about unconscious bias a lot. We typically talk about it in terms of gender, but it goes much deeper than that. So the first thing, our characters will influence us both positively and negatively against other people with either the same or the opposite character. One example, if you're somebody who comes to a decision quickly, you will tend to feel that anybody who's quite laborious in the way that they proceed in their decision-making process is stupid. Equally, somebody who is really thoughtful and rigorous and goes through all the different processes to get there will think the person that goes quickly is reckless, untrustworthy, cavalier. And therefore, you've got to know yourself, and this is particularly important when you're looking at witnesses, to work out whether you trust what a witness is saying. You've got to understand your character and the witness's character to see whether there's any unconscious bias influencing how you're reacting to that witness. Another one is experience. So if you're somebody who's worked in a particular industry, you will, whether you like it or not, have learnt certain views about the way the industry works. Geography is the same. If you're used to working in a developing country, you'll have a very different view of how commerce should work to somebody who's only worked in a developed country. Again, if you look at investor-state disputes, if you've predominantly worked for an investor, you may have a certain cynicism towards the state. Equally, if you've predominantly worked within a state in their in-house legal department, you may well have a cynicism towards an investor. All these different experiences impact upon how we view and decide a particular issue. Now, I'm not going to stray into ISDS because we're going to go to that in a minute. But the final area where I see differences actually is in age. Now, you can see this very clearly. I'm going to be parochial now, but the difference, the way that the public view Harry and Meghan, Prince Harry and Meghan, and Prince William and Kate. And you can see a lot of reports in the press of people being very critical, the older people being critical of Harry and Meghan for being emotionally open, admitting of vulnerabilities, and the younger generation being very critical of William and Kate for adopting the stiff upper lip, very English mentality. Again, that will impact on how a younger lawyer may view a witness that wants to admit certain vulnerabilities in things that they've done, maybe admit mistakes that they've made, and ditto with a witness who doesn't want to admit anything. So finally, I just want to end up where I started with gender. Now, I talked about how when my husband and I drive, he refuses to ask for help. Well, this is one area where I think gender can make a difference in terms of decision-making. Because I've sat on tribunals with women, and I'll happily do the same myself. If I don't understand what an expert is saying, I'll ask, please help me, I'm really not following this. And again, as I said at the beginning, gross stereotype, I apologize to all the men here because I'm about to be less than polite. But I would suggest that it's more of a male characteristic not to want to admit that you don't understand something or that you need help. I'm not suggesting that a male arbitrator and a female arbitrator will get to a different decision, because ultimately, I think if you're good, you'll all get to the same right answer. But I would suggest that a female arbitrator may be more willing to admit the vulnerability, the lack of understanding, and a male arbitrator may decide that they don't want to admit it and they'll try and work it through at a later date. So, finishing hopefully within my time, and without wishing to offend anybody, as I said, this is very stereotypical, it's very nuanced. But those are just some areas where I think there are differences in the decision-making process.
Right. So next, the first, open the discussion, Filipa.
Thank you. So Andrea yesterday asked me to create a bit of commotion and, and discussion. So if I say anything that strikes you the wrong way, that's what I'm doing. But I don't think I will say nothing very shocking. I was thinking about what Juliet was saying, and unconscious bias is really a big topic in general in humanity nowadays because we don't know why we take the decisions we take. And so the literature suggests that the more diverse our panels, the better decision you may be able to get, because since part of what influences people is their experience, background, frames of mind, if you get to the right mix in a tribunal, they will hopefully counteract each other in their biases. So going beyond gender and beyond age, because sometimes people of the same, of different gender or of different ages may have more in common and may have the same types of biases than people that are all the same, that are more diverse. So this is one of the things that I wanted to say, that you need to be really, really careful when you're structuring a tribunal, so that you have the right mix of experiences that can contribute to the decision we want to obtain. And the other thing is that I'm always, you talked about international arbitration experience, and I think that's exactly the point, because we lose hours of our lives discussing the differences between common law lawyers and civil law lawyers. And I went to a conference on cultural differences on Monday, and I thought, oh, this is good, it will help me prepare, but it was about UK lawyers versus US lawyers, so, which just goes to show that the generalization of civil lawyers and common law lawyers is just as an oversimplification. But what really, I think, makes the difference, if you are someone trained in international arbitration and you have a lot of experience, perhaps sometimes you will still go to your primary legal education, but you will have a much more open view of arbitration. And I think what perhaps sometimes makes a difference is whether you were trained as a lawyer, professor, or a judge. And I feel that you're getting restless, so I'll finish.
There we are. That's the regulation by raised eyebrow. Donald.
So we've obviously talked about a bunch of different characteristics that can be organized along a bunch of different axes, including I can't help but repeat Mark Twain's comment about the US-UK, in connection with the US-UK lawyers, describing the United States and the United Kingdom as two countries divided by a common language, which may, for these purposes, just warn us how difficult it is to make these kinds of judgments and to make these kinds of inferences. And so I'm going to restrict myself to just 3 observations. First, it surely should be the case in looking at a particular decision maker that specific hardcore expertise, for example, knowledge of the business practices within a particular jurisdiction, knowledge of engineering in a dispute that's going to involve engineering matters, a whole range of things we can think of like that. That's going to affect that person's decision making, but hopefully in a straightforward way, in making him or her more capable of understanding the context and therefore being in a better position to make a wise decision. The second category that we've talked about here is, of course, legal background. And again, although all of us are used to working in different contexts, and I, for example, feel strongly, this is the caption lecture I gave you about 1.5 years ago in Hong Kong, that as lawyers, we are capable, not as becoming expert Brazilian, Japanese, South African lawyers, but in understanding legal materials without reliance on expert witnesses. Certainly experts in the applicable law, but as advocates, because we do have the tool set to figure out what legal materials say with the guidance of, as I say, advocates in that particular place. And I bet many of people have my own experience. It's very hard for me to think of cases in which, particularly with respect to contract interpretation, where the applicable law would have dictated a different result. I can think of 1 or 2, perhaps, as it happens out of Brazil, which has, in my view, a very strong view of good faith, where, had it been a New York law contract, it probably would have been the issue itself. But having said that, we certainly, if we have particular training and the like, we are going to approach particular legal issues in a particular way. I think of as an immediate example, if anybody's had a chance to read Judge Cansado Andrade's a separate opinion in the Ukraine-Russia case that came out a few days ago, or any of his opinions in this series of cases involving human rights. He obviously takes an extremely strong and distinctive human rights approach to any issue under international law. That does, of course, you would be aware of that. You would expect that from the judge, and as it happens, you would get it. The third category is the one which I think we really are completely in the dark. And the third one is, but again, it's come up, things like gender, ethnicity, geographic background, these things that make us human, that are part of who we are, that are essential pieces of who we are. Predicting how they will actually affect our decision-making, I think, is brutally difficult, and so far as I can tell, we have very little reliable data on it. We can know, I think, instinctively, as I say, they are an important part of our identity as human beings, but I think it's very difficult to try to map out how they might influence a particular individual's approach to a particular issue and dispute.
Ricardo, do you want to add anything on this?
Well, first of all, I want to thank for being here. Thank you, André, for organizing it so well. Briefly, I just would like to say that when it comes to civil and common lawyers, basically in a way, it's just like the path about husbands and wives, because we start from a very different starting point of view, but I don't think we always reach to different conclusions only because we use different paths. Civil lawyers are less worried about how tribunals, how judges decide things. We first go to the law, and we are very worried about how our statutes and acts and how does the law provide about that situation. But we also go always as well to tribunals and how things have been interpreted, because maybe these two systems are now so in touch that we cannot understand. We start by the law, but we cannot understand how we apply the law without this kind of I would say, common law approach. In a way, we are getting together. I would say, at some point, I might ask for ask someone how to reach to my final destination, even before my wife starts saying, "You should have done that before." I might do that briefly, in a way.
Well, I live in Oxford, and I asked the directions to Wolfson College twice as I walked from my house. So I must have a serious conversation with my wife.
I want to change my husband.
But we're going to have to move on to the next topic shortly, but has anybody been struck, provoked, and wants to make a comment or ask a question on what we've heard so far? Just say that on this question, the Anglo-American difference and Mark Twain, when I first, after 25 years teaching at this university, I went to Cambridge, and lots of people said, "Well, what's the difference?" And I decided I wasn't going to play this game. So I said, well, it just depends where you are. If you are standing here in the middle of Oxford or in the middle of Cambridge, you notice there are quadrangles against courts, there are big colleges. If you're on Mars, they look exactly the same. And so actually, these biases and differences are all a question of perspective. And I'm probably more likely to notice the difference between the English and the US approach than somebody from South America or from another system. Our next topic is economic and other behavioral incentives. And the lead is Filipa. She's going to start us off.
Thank you. So incentives are a cornerstone of modern life, it has been said. As Donald said, they are part of who we are. And science today shows us that incentives, that humans respond to incentives from the beginning of our lives, positively, negatively, and many times subconsciously, which is a very important point. And some people wonder, in this context, what does this mean for arbitration? Does it mean that when you're an arbitrator deciding on a jurisdictional objection, you may be inclined to rule on the decision that will get you more money? Or if you're deciding your own fees on an ad hoc arbitration, yet another very good reason not to have ad hoc arbitrations. Or if you pick another example, regardless of arbitrators' motivations to sit as arbitrators, it's reasonable to assume that arbitrators will want to be appointed again. Does this mean that we favor, for instance, repeated players over one-shot participants in the proceedings, or that we are tempted to favor a party that has appointed us so that they will go out and advertise our services saying, oh, this is an arbitrator that really delivers. And if you think about it in terms of common sense or using the theory of the rational economic actors that most of us use in in DCF analysis and things like that, you think, yes, it seems that we have an incentive to go down that road. But modern economics also tells us that common sense is often wrong and that we are predictably irrational. So where does this leave us? If you look around, we see many examples, which are not perhaps statistical, but anecdotal evidence of arbitrators acting against their short-term economic incentives. So if you take, for instance, many arbitrators that are starting out their careers now, they will take cases that have a low value and will yield relatively low fees, and they will devote themselves to them as if they were the most important thing in the world, because they are trying to get it right, to build a reputation, to have a track record. And so this serves for me as a proxy that illustrates how sometimes your short-term economic goals are pushing you in the opposite direction of your long-term economic goals. So that's for the economic incentives, but there are also other incentives that are as important or even more important than economic incentives. Social incentives, how your peers perceive you. You don't want them to see you as biased or incompetent or lazy, or in moral incentives. Usually, people tend not to like to do things that are wrong. And so, if you think, as economists do, as incentives, as a means to get people to do more of things that are good and less of things that are bad, it's a question of putting the proper incentives into place so that arbitrators will be what we as a community, I believe, want arbitrators to be. People that solve disputes in an efficient and fair manner so as to get to an award that is final, binding, and enforceable, and that takes proper account of the evidence produced and of the legal rules. And from that perspective, I don't think we've nailed it perfectly, but I think that in commercial arbitration at least, we are in a more or less organic way putting into place the proper incentives through many different ways. But now, sorry, I only had 4 minutes and I'm done.
Thank you. I didn't even get restless. Ricardo.
Well, I'm gonna first I'm gonna join this question with at some point we will discuss dissenting opinions, and I think these two subjects might be connected. If you were a party, or when you are about to appoint arbitrators, there is this point of view, but you can also we can also have this discussion from the arbitrator's point of view and what are the incentives once you were already there as an arbitrator. Filipa said about jurisdiction decisions. I think it's fair enough to say that generally an arbitrator would like to be appointed again. Generally, an arbitrator worked very hard to get that first appointment or to get that position. So when it comes to jurisdictional decisions, there are two things in the table, I would say. Should I end up this proceeding right now and stop my own work? Is it how much? I always think about how much does this interfere in the decision process. I will consider the argument and I'll stop the proceeding, and it was just beginning. This is something. and I'll probably get less money because of that decision, and that might influence on my decision on considering the jurisdiction that I have jurisdiction and move on the proceeding. On the other hand, I think we all must also acknowledge that arbitrators, once they want to be appointed more and more, they have a very big concern on making the arbitration proceeding stand and providing the award from being set aside. In that sense, I think the incentives would work on the opposite way. I will not go on a proceeding, or I will not take any decision that might jeopardize the proceeding itself. I think these are two separate, and in a way they conflict with each other, these two incentives. And there's not an answer. You either you don't do it, or you always go further on proceedings, or you always stop proceedings about jurisdiction because you are afraid of setting aside decisions further on. Sorry.
Juliet.
I've got 2 points to make. I completely agree with both of you that what should be done is that you do the right decision for the case. And that's what the vast majority of us aspire to do. It's not what 100% of us aspire to do. And there are, I've been told by lawyers, I will not appoint this arbitrator again because they found against us. Not because they found against us and actually it was right to find against us, but I won't have somebody who finds against us. And anecdotally, you do hear of a very small minority of individuals who are known to find in the way that their party wants them to find. And we have to be realistic about this. It exists and we have to know that. It actually doesn't do the party any good because very frequently what you'll see is that the other two members of the tribunal will be pushed together, and all that will happen is that it'll be a majority rather than a unanimous award. You can also see it when, if you're drafting the award, the dissenting arbitrator actually wants their name put into the award as it was found by a majority, footnote, this was the arbitrator who dissented. And you know that it's likely that's signalling they want to say to the party that appointed them, look, I'm on your side. So I'm not coming up with a solution, I'm just saying we need to be aware that this economic pressure does exist. Most arbitrators, I think, are smart enough to know if you have a reputation as being a good lawyer, honest, you will listen to your party, you will make sure your party's case is understood in deliberations, but if you don't agree with it, you don't fine for them. The second pressure is not economic, it's due process paranoia. And that is increasingly, I think, a pressure being put on tribunals, whether it's guerrilla tactics or just obstructive tactics from a respondent who's trying to find every way to delay. It is a difficult balancing act for a tribunal. You've got to be confident, you've got to be experienced to know when you stand up to a recalcitrant respondent and don't play their game and you're firm, but also keeping your eye on the fact that ultimately your aim is to get an award that's enforceable in the jurisdiction where the assets are. So you don't want to put the parties in a position where you're giving an award that can be challenged for lack of due process. And that, depending on the jurisdiction, depending on the parties, can be quite a difficult balance at times to get. And it's a pressure that I think is becoming increasingly, it's happening more and more. So those were the two things I was going to add.
Jack, can I ask a quick question? So Juliet, in that situation, to what extent are you guided by the party whose award will be at risk? In other words, you have a situation, there is developing what looks to be obstruction. The tribunal, of course, has an obligation to protect the integrity of the award. On the other hand, the party that is subject to what the tribunal may perceive as obstruction has the most immediate interest because it's going to be trying to enforce and defending the award if that's the assumption. So if the party itself is saying, not another round of briefing, or we're not going to have a separate phase, to what extent does the tribunal have should it take into account, well, we're more worried maybe the party isn't being prudent, so we're going to add more process that will delay, even though it appears that the party is prepared to, if I may put it this way, take the risk?
This may not be the right answer, but this is the way I see it. It does depend on it's almost always the claimant party, how experienced they are as counsel. So, for example, if it was Debevoise, if it was probably most people in this room, I would take the view they know the risks, they must have weighed it up with their clients. If they're saying, look, we want to move ahead, then I would take that view and say, fine, we're going ahead. We're not allowing a further time extension. If, however, you've got a party represented by a relatively inexperienced counsel, it's harder because they may not have thought through the issues. One very quick example, we had a non-participating respondent, and the claimant suggested moving the seat to where they were based rather than keeping, as in the hearing seat, not the ultimate seat of the venue rather than the seat. They hadn't taken into, we the tribunal didn't think they'd taken into account issues of enforceability. There were very specific rules in that specific jurisdiction about hearings and where they should take place. And we really struggled as to how much we should say to the party, because even by hinting to them, had they thought it through, that in itself could have been a breach of due process. But that was where we had to be careful. But if it was a sophisticated party, I would listen to them completely.
Right. Any comments from you? Yes, sir.
So thank you for your question, Peter. To be fair, I act as arbitrator, so I was not suggesting, so lest there are any doubts, that arbitrators were essentially motivated to get more appointments in an unethical way or in a misincentivized way, or to get more money. What I thought, and I think a lot about the legitimacy of the system as a whole, and it preoccupies me when people can have legitimate doubts. They may not be correct in the end, but there are legitimate doubts now that we know that sometimes we are incentivized by things unaware that we are not aware of. And so I agree with you that getting reappointments is a very complex function. And so to my mind, what may work is that you excel at your job in accordance to the rules that are in practice. And there is a lot of competition, which is good because I think it brings out the virtuous arbitrator against the others. As Juliet was saying, I think there is a cost. You can be a partisan arbitrator with some success for a while, but you cannot have a career as a partisan arbitrator forever, because you will lose your clout with the tribunals because you'll get a reputation of someone that is biased. So I think that I've always thought this: if ethics do not convince you on the face of it, do it because it's more beneficial to you in the long run. So it's the paradox of the goose of the golden eggs. You cannot kill the golden eggs, rule on jurisdiction to get more money. You should keep it alive, be the way you're supposed to be, and hopefully that will get you more appointments in the future because you are perceived as a good arbitrator.
I think that as Ricardo, it's keeping an eye on the time, as Ricardo said, there's an overlap between this and the last session and the issues about dissenting opinions. It's a subset of this wider issue. Perhaps we'll come back to that at that stage. And now, if we move on to the appointment process in investment arbitration and the repeat arbitrator problem, Donovan's going to kick off.
Yes, happy to. So this is a subject, obviously, that we talk about endlessly, and the role of the party-appointed arbitrator is certainly one of the phenomena that is driving the move for reform in investor-state dispute resolution. It is really just, it's an aspect of the structure of the system. We're talking about three related features. First, the system is radically horizontal. That is, there's a series of cases who do not, as a legal matter, have any influence on the next. That is, there's no precedent, there's no rule there's no control by one decision over another. The second is that these cases all arise on an ad hoc basis. That is, they may arise under a wide range of treaties. The treaties may be related or not, but they're basically one-off dispute resolution mechanisms. And then, of course, the third feature is that the arbitrators appointed are frequently arbitrators who are experienced, who are well-known, and because at this point, it wasn't always so, but at this point, these decisions and awards are almost always virtually immediately public. One forms a view, or an arbitrator develops a reputation because his or her writings, his or her views, his or her votes are a matter of public record. So what effect does that have on the system? The question was posed is there some benefit to that? That is somebody who is regularly seen as, for example, solicitous of the interests of a state or solicitous of the interests of an investor, does that person bring something special to the deliberations? I wouldn't put it that way. I should state at the outset that we have, and all of us can think of them, there are people who are regularly or even exclusively appointed, either for states or for investors, who are absolutely first-rate lawyers, who are absolutely first-rate arbitrators, and who sincerely hold, at least for the folks I know, without a doubt, the views they espouse. But they see the body of law in a particular way, and that particular way does tend to, as I say, protect either the interests of investors in one case or states in the other. So is that a good system? It is part and parcel, of course, of any party-appointed system. What do we look for? I mean, from when I first started practicing, what's the ideal party-appointed arbitrator, I was told? Well, it's somebody who is going to, by background and education and by instinct and temperament, appreciate the point of view of the party you are representing, but on the other hand, both do and be perceived to be doing justice. That is, both to be independent and to be perceived to be independent. Now, we can question whether or not that's a completely coherent view, and Juliet just to some extent repeated frequently heard mantra, well, you want the arbitrator to understand your case. Well, yes, but you want the arbitrator to understand the other case too. You want to understand the arbitrator to just work straightforwardly. Yet I don't think it would be considered improper to go through the kind of rigorous selection process, rigorous review that we all do before we appoint an arbitrator, to ensure that we have appointed the right, so to speak, an appropriate person, given there is a degree of, if I may use the term, advocacy in exercising your right to appoint one of the arbitrators, one of the people who will indeed take on the case. But it is all those features which I think are perfectly proper in the current system that in many people's mind suggest that we need to reform the system. Because you do have, and again, we'll talk about this, even there are overlapping considerations with respect to dissents. You do have in the investor-state system important public interests. And yet we do have a model of appointment under ICSID and most treaties and the like, where individual actors, including both states, of course, and investors, are making the appointments of these arbitrators. And so you have an actor, one of the affected party input, as opposed to what I would think of as a more public model, whether it be on the national or international level, whether it be a national court where all of the judges are appointed by the polity that legitimates the court itself, or if you look at it on the international level, the ICJ, ITLOS, whatever, in the same situation where all of the judges are appointed by the community, the political community, the treaty community, that in fact gives legitimacy to the dispute resolution system. And that is just a fundamentally different model.
Thank you. Juliet.
Thank you. As counsel, one of the most important jobs you have is appointing the arbitrator in a system, as Donald's just described, where you can appoint one of the three. And in ISDS, the first question is, well, are they pro-state or pro-investor? And everybody pretty much knows who the pro-state and who the pro-investor arbitrators are. Does that mean they're biased? I went to a brilliant conference where a very eminent jurist said, well, you could say they're biased. You could say they have a very strong empathetic tendency to see the law as supporting one side or the other. But either way, however you phrase it, you're pretty certain of the views that experienced arbitrators in ISDS have. What that can mean is that the decision rests with the chair. If you've got a pro-state and a pro-investor arbitrators, the one that is you can't be certain about is the presiding arbitrator, who, not always, but may be appointed by ICSID from a panel they put forward. Now, that can make it quite interesting, because that presiding arbitrator, the first ICSID case I did, the presiding arbitrator not only knew nothing about investor-state, but actually knew very little about arbitration full stop. They were a former ambassador. And it was actually very frustrating trying to educate this person into what was going on. And it was also frustrating because we had two diametrically opposed co-arbitrators, very pro-state, very pro-investor. So it was clear that the presiding arbitrator was going to be the one that would decide it. You wouldn't get that in a system where you have a panel of arbitrators that are chosen by the community, as Donald was describing. Equally, what you lose is your ability to choose your arbitrator, and particularly in any arbitration, but particularly in investor-state. The issues are so deep, and it's not just a case of a commercial transaction that's gone wrong. You're talking about issues of environmental law, potentially, climate change, what your taxpayers are having to suffer, what the citizens, the nationals, and maybe the area that the dispute is over, what they may be facing. You've also got the investor that will have pumped a ton of money into a country. You know, these are really deep issues. You have to have transparency, which you don't get in commercial arbitration. In those scenarios, you can understand why the parties want the ability to choose an arbitrator that they feel will understand their case, will also understand the other side's case, will come to the right decision, but hopefully the decision that's right for them. So I think this is an ever-moving area. It's got a lot of issues that still need to be sorted out. I don't yet have a feel for which I think is the right way to go forward. I just know there are going to be many changes coming up and a lot of criticism.
I've got 2 points to make. One which all the heavy practitioners will probably pour water over. There was a 2010 study published in the Cornell Law Review, which did a survey of many ICSID decisions to test for this, and the conclusion was that the repeat arbitrator phenomena did not result in the analysis was that it did not result in what I'll call proper bias, as opposed to the sort of starting point position, because of the firm commitment to professionalism and expertise. As far as the second point is, and there are several other studies as well. The second point is that on issue conflicts, it seems to me that it may well be that arbitrator A has come to a particular decision on the meaning of words in a treaty on several occasions. The issue is whether that arbitrator has got a closed mind or not. And there is that, the Devas in India case, in which the arbitrator the arbitrations were annulled, and the arbitrator then wrote an article saying he was right. You know, when I was a judge and I was overruled, I so wanted to write articles like that. But actually, you don't do it. And so the key issue is, have you closed your mind? And if you've closed your mind, you are not bringing that professionalism and expertise, which I hope all of us who decide things, have to come to. There will still be people who are more on one side than the other. That's why you have multiple party arbitrations.
Jack, can I ask you a question first? Do you think people know that they've closed their mind, or do you think people believe they have an open mind when their mind is closed?
I think it depends on the person. I used to say about the late Professor Sir William Wade that if I was as certain of anything as he was of everything, life would be good. But on the other hand, not being certain of anything is also not good. I think some people don't know their mind is closed. But then that is why you have multi-party tribunals. That is a safeguard,
But I think
particularly in a horizontal system.
I think the appearance of impartiality dimension is extremely important with respect to issue conflict. I mean, it's just very hard to see how somebody can be, on the one hand, deciding an issue and either himself or herself arguing the issue or having somebody within his or her firm. It's a structural problem.
That's a different point. That's a tribunal counsel problem partly, and I agree with that. I agree with that. But
May I
yes,
just two
please.
quick points on that? There is a very good article from Garavi, I think, talking about arbitrators that act in the ad hoc committee overseeing an annulment proceeding while they are arguing something. So they are in a position where they can create the case law
Right.
that helps them in their case, which not calling into question the integrity of the arbitrators, but the thing is the perception of bias is the thing that destroyed, together with some arrogance on our part that we thought that we shouldn't address criticism at an early stage, is destroying investment arbitration as it was and is trickling down commercial arbitration. And again, for legitimacy's sake, we need to address the concerns of the people, even if they are wrong, but we need to understand that they have a reason.
If Jack will forgive me, indulge me a quick plug, there is an extensive work product as a report by a joint task force from ICA and the American Society of
Yes.
International
Was
Law.
that when you were in charge?
Well, it was when I started when I was president of ASIL and I finished when I was president of ICA. But it's a very good group of
Yeah.
people. And it was interesting to watch because even though it really was born of exactly these kinds of issues, but it's an extensive discussion, but they do not come down with very firm, they found it very difficult and they were appropriate, I think,
Yeah.
measured. Laurence Boitasson de Chazorn and John Crook were the chairs. It's if you're interested in that issue, forgive me for plugging, but it's really first-rate work product.
It's a good thing to plug. It's a very good one. And they don't even agree on what issue conflict is, really. They're
Yeah.
very open-ended about that.
Yeah.
I do think, though, that the consequence, unless you go, as Juliet has, and you become only an arbitrator, but even then, in this context, her decisions will be public. So if she's consistent, is that going to preclude her from then sitting? And if she's inconsistent, is that actually a good thing, which will encourage people to nominate her? It's slightly paradoxical.
Or think I'm a lousy lawyer because I don't know my mind.
Well, I think there's a real difficulty, and that is, I think that is one of the consequences of this method of not having of having party-appointed arbitrators. Does anybody want to jump in? The panel got so excited with this that we're not leaving you much time. Shall we go on to deliberations then? How they occur, what happens when one arbitrator refuses to engage? What happens when one arbitrator is in another arbitration on the same similar issue, and the two, while a draft in one arbitration is circulating, there is already a draft, an award agreed in another one, and the person who's on both arbitrations shuts up about it. Ricardo.
All right. Well, this is a very... sorry, I have to... No, just to stick on time. Well, deliberations and what happens if one arbitrator refuses to engage. First, let me start by saying we shall understand the deliberation process either as a duty for the arbitrator and also as a right. One arbitrator cannot be prevent from deliberating. So, two members of a tribunal should not start deliberating, exchanging drafts without communicating with a third one, even if this third one had behavior not properly during the proceeding. It's a tricky thing, but this is something that we should consider. But from the duty point of view, one arbitrator also can never refuses, as a theoretical answer, I would say, it should never happen. You have to make yourself available, you have to comply with the command of the chairman or the chairperson. Usually, we should also consider that the deliberation process should be scheduled and arranged by the chairperson, I would say, since the very beginning of the proceeding. The same way we have a calendar for the parties, arbitrators might know the moments that when they have to decide things, and they have to arrange a proceeding for that. So we first make a call or a meeting, then the chairperson will send the first draft, and there is a due time for a revision. This should all be really be organized. Well, from a law point of view or arbitration rules, you don't have, usually they are silent about when the arbitrator refuses to engage. You have, for example, New York Convention talks about the formation of the tribunal, but doesn't talk about the problems in the deliberation process. You have the model law saying, stating a very good rule. The majority rule shall prevent major problems, because it might happen that the award has to be rendered without one of the members. And how do you keep the validity of the proceeding in that situation? Well, the rules, at some point, the majority rule must be there. Is it in the law applicable? No. Is it in the arbitration rules of the proceeding? It has to be somewhere. Because when it's not, you might have a bigger problem, because how to issue an award, a majority one, without any legal basis to allow that majority rule. In Brazil, we have, our Brazilian Act has a very specific provision. We cannot, we don't have a provision saying that only two arbitrators can sign the award, can issue the award, only two of them, but the majority rule is the rule that we have in our legal system. We don't have two-member panels. We need either one or three members. So it fits with the majority rule. I understand that English law has different provisions, but when it comes to a three-member panel, in a way or another, the majority rule will apply. So there are, I'm just mentioning Brazilian and English legal systems, because just to point that there are some legal systems that are more, in a way, prepared for those situations. They happen. The fact that they shouldn't happen does not prevent us from saying it happens, and sometimes it happens for the worst reasons, because there is a counsel in the tribunal, there is a person who was not supposed to be there or who's not behaving properly, and this is something that the other ones have to comply with, and I don't want to, I'll do it again. This is also something related to dissenting opinions, and so I'll stop here and leave the floor for the subsequent topic.
So the next stage in the conversation, Donald.
So I think it is the case that deliberations can be had in a variety of ways, and it will depend on the expectations of the members of the tribunal. I think a first principle, of course, is that all members of the tribunal should have the opportunity fully to participate in the deliberations. Whether that requires everybody being physically present, or whether you can do it by video. I recall a case years ago, and I was still relatively young arbitrator with a very senior member of the field, but we had a third arbitrator who was a judge in the city that was the juridical seat, and he insisted us on us coming to deliberate the case, and we went. And it was, for both of us, a very long and inconvenient trip because the juridical seat was a city that was not easy to get to, but it seemed obvious that that was, in fact, the appropriate thing to do in order to both satisfy, he was also elderly and couldn't easily travel, in order to make sure that there were appropriate deliberations, in order to make sure that we could always prove that there had been appropriate deliberations. In a situation in which someone is actively trying to obstruct deliberations, it obviously does not follow that you have to do, this was a request, but it's completely in good faith. It does not mean that you can allow a third member of the tribunal to obstruct the work of the tribunal. I think it is the case that it doesn't often get to that point, but it does. We all know of certain instances where a third member is more interested in that the tribunal not achieve its work than that it does. And in that situation, again, I think the tribunal, led by the president of the chair, needs to be very decisive about making sure that a fair opportunity is given to the entire tribunal to deliberate, but at the same time that is capable of being demonstrated, because deliberation does have its own value. We all know of situations in which we thought one thing and we talked to other people and our minds were persuaded. It's the same thing even in the course of writing. You hear it almost as a cliche, but I think all of us have had the experience where, it didn't write. You thought you knew what you were going to decide, and it didn't write. And it's that kind of rigorous process that's really important. On the other hand, I don't think one has to be formalistic about deliberations. And I've had deliberations with tribunals where you understood that you basically agreed with the deliberation, really went forward virtually in writing. The chair or some combination of the members of the tribunal circulated drafts. People had full and robust comment on the draft. You got on the phone to talk about the stuff that might or might not, that you might need some work, but I don't think there's any formal requirement that everybody sit together in one room and say, okay, paragraph 1 of the statement of claim. I think it really all depends on the situation, and we are enjoined, as we know, under every modern set of rules to be efficient and effective.
Yeah, and I'll only add as a footnote, really, that if it becomes clear that there's a difference of opinion after appropriate deliberations, then there is the question about whether the recalcitrant, or so the minority one, who may be right in some abstract way, can continue to seek to persuade the majority of the errors of their ways, whether because of a true belief in his or her juridical point, or just to delay the award. And the answer is there comes a point where you could say no.
But
that's a very, what's the judgment
it's important,
on that?
Exactly, to give a dissenter a chance to elaborate his or her views and then to express them. But if one starts to get the sense that this is really unduly delaying the work of the tribunal, at the end of the day, you're there to give the parties a decision.
Jack, can I ask a question?
Yes.
Do you think after the third member of the tribunal is decisively she is going to decide differently, the two others, in your experience, do you think the two others from that point on can or might deliberate by themselves without the third one, or the whole group must be together the whole time?
I think that when the first, my own, and everybody's experience is there, and my own view and experience is that when there's a first indication of a difference of opinion, then actually you can go on discussing, because to see whether the differences can be narrowed, whether they can be eliminated. There comes a point when you're not doing that, and it's just a question of me trying to persuade you that you don't know what you're talking about. I think you're allowed to say enough. And then it's a judgment as to whether, and then as Juliet asked, how do you know about your biases? How do you know when you've really given them enough? Well, it's a question of judgment and experience. And I think that's what you do. But there comes a point. It is very difficult. Do you know, and this is the same thing with judges. This isn't a thing peculiar to arbitrators. I've sat in an appellate court, and with some tribunals, with some courts, it's all extremely smooth. With some, it takes a long time, and you generally tease it out. But there comes a point at which everybody understands that enough is enough. And what you've got to do, though, is to be able to show in the record that the dissentient was given an opportunity, a real opportunity, a realistic opportunity, and that you haven't just trodden over him.
May I just have a quick point? If I understood that you were also asking whether it is
Whether to take
legitimate. Sorry?
No, you're
legitimate to take part. Yes, I
Legitimate
didn't deal with that.
one thing is to say what, as you were saying, okay, so you did not convince us, we did not convince you, so let's proceed. But I don't think, at least in some jurisdictions, if you continue to deliberate without the arbitrator being there, you are putting the award at the risk of being denied enforcement or being annulled because you cannot exclude an arbitrator from deliberations.
Yeah,
So that's a second part of what you were saying. I
Yeah,
think.
that's also my perspective.
I didn't address that, and I think that is right in some jurisdictions. Of course, in some cases, you get a draft award before the deliberations have started. That's a different issue. Any questions, comments? Yes. Yes. You. Yes. You. Yes. Well, compromise. I think that compromise is part of being open. The Solomon idea of just cutting the baby in half, regardless of the merits and whether both halves will bleed to death, it seems to me not a good idea. Again, the Cornell study that I showed suggested that there was less of that than is sometimes thought. But in my experience as a judge, it happens, and there are things on which you can compromise on, and the things on which you can't. I don't know. Others have different
To me,
experiences.
this leads directly into the discussion about dissent.
It does, and I wonder whether we should move to that because we're coming to the. But let's. I myself. What I worry about with these compromises is that they lead to incoherence. But then you people who are all arbitrators, and there's some of you don't like former judges. I know. You see?
Depends on the jurisdiction.
It's on the jurisdiction, but compromises are of different natures, and compromises can lead to very bland judgments where you don't actually know what the decision is. The judgments of the Court of Justice of the European Communities is sometimes criticized for producing apple pie and motherhood to all things, and you don't understand it. So, but I don't think that's the sort of thing you're getting at. You're getting at, well, we'll let you win on point A, and I'll take point B. Yeah. So, shall we move on to dissenting opinions? And perhaps we can just bear in mind that question about compromises in the course of that. Donald, you're leading on dissenting opinions.
Yeah, because I think that the issue you've just raised is exactly the concern. Well, it's one of the two issues when you talk about dissenting opinions. It's the first thing is what's the function of a dissenting opinion? Is there in a particular circumstances any need for a dissenting opinion? And secondly, at what point does the prospect of the dissenting opinion become the occasion for a compromise in a sense that we probably would not be comfortable with? And to tee this up, I do think it's worthwhile to think about three different contexts because they each feed each other. The first is a national court, in which now, of course, I'm talking about a multi-member national court, presumably an appellate one, which is, of course, going to be public. Secondly, a commercial arbitration tribunal, where the result is not likely to become public and is not likely to have any impact on French law, English law, South African law, Japanese law, whatever. And then the third is an investment treaty tribunal under whether a contract or a treaty, which is likely to become public and may, even as a matter of formal international law have an impact on the development of law. And as we know, regardless of the formal status under international law, is going to be part of this marketplace ideas that dominates the investor state. So those are three different contexts. Secondly, the question is whether we're in a commercial sphere with respect to the substance, or the affinity between constitutional law, public law, treaty law. Again, two different axes we could keep in mind. And then thirdly, which I've already suggested, the difference between something that's going to remain confidential and never see the light of day, and something that's going to be publicly available. So when we're talking about dissents, what's the function? Speaking for myself, I would think that it is rarely the case that there's a purpose served by a dissent in a commercial case. There is a real value, even in a commercial case, let alone a public case, to having the tribunal speak as a single voice and to render a decision that will resolve the case for the parties. Now, there will be exceptions. A couple years ago, I wrote an extensive dissent in a commercial case, and I started by saying the threshold for writing a dissent in a commercial case has got to be really high. I might have said to myself, it has to be really high in an ICC case where you're not getting paid to write the damn thing, right? But it was a point which I really thought the tribunal had gotten wrong. It was an important point, and I really got to the point where I didn't feel like I could sign the majority. I didn't think that anybody was acting other than in good faith, other than bringing their full critical faculties of it, but I just fundamentally disagreed. By contrast, a long time ago, one of the first cases I chaired, it was an ICC case. It was one of those very difficult contract cases in which there was just a lacuna in a contract that was going to last 100 years between two major companies. And they just forgot to deal with an issue. So you're in a situation where you're trying to find a clue from Article 22 and compare it with the clue from Article... And there was no real right answer, and yet one of the arbitrators dissented. And I thought that really didn't make any sense. So I do think there is real value to the tribunal speaking as a whole. And for the most part, in a commercial case, there would rarely be. But as I just said, never say never. With respect to it, just as in, I think, a national court, and particularly a national court dealing with a public law or constitutional issue, if we're in an investment treaty standpoint, then there may well be more reason for dissent, because this is something that will, in fact, develop the law. Now, is it worth dissenting on some fact-finding, whatever? My earlier views would apply to that kind of thing. That would have to be something where you really felt something went so badly wrong that you couldn't really sign on to it. But with respect to the interpretation of treaty provisions that may well recur and do, in fact, involve important public interests, I would put that in the same character as national courts, particularly national Supreme Courts, that really are going to continue to develop the law. And as we've said, these decisions may well be under formal international law, part of international law, but in any event, they have a real the capacity to influence the development of that law. So then we get to the question that we started with, which is, at what point is it a compromise in a bad sense, and at what point do you buy off a dissent by giving way? I don't think that a multi-person decision-making body, that there's anything wrong with listening to other people's views and accepting the notion that even though you still are kind of persuaded that you're right, that there's another point to the story, and that you would achieve some real value by having one decision, one point. Where I think something becomes an inappropriate compromise is the last example we just said. Well, look, I'll agree to this point, but I want, $10 million less on damages. Well, you really are horse trading in a way where it's not part of an attempt by a multi-person tribunal to come to one intellectual result, but you're really horse trading on issues, on interests rather. And that is, I think, where it may well get to a point that is inappropriate and someone should just dissent. The dissent itself, to me, it's not necessarily a badge that you've dissented. I always think, I'm going to use a parochial example, but Justice Stevens of the United States Supreme Court was a brilliant guy. He had been a practicing antitrust lawyer before he went on the Seventh Circuit and then the United States Supreme Court. You could tell he was a practicing lawyer because he always picked up stuff that some of the justices didn't always do. But he always just wanted to write separately and lay that out. And he would have been so much more, in effect, for those, you can tell what side of the court I'm on. He would have been so much more effective in the face of the increasing darkness on that court if he had really looked to collaborate and put together alliances to particular results. But he just had a superb mind, that he was, a spectacular individual, and he chose not to. But I don't think there's anything wrong, to be clear, with trying to forge a common view that not everybody has to fully believe in, like bounce on the table, but that will in fact provide a result to the parties. And even in effect, in the national court, there's one famous Supreme Justice, I can't even remember who it was, who said, there's some things about, we just have to, it doesn't matter what we decide, so long as we decide, right? That you resolve the issue, that the law achieves clarity, people can guide their conduct according to that. That is frequently the case. Likewise, you have a dispute between commercial parties. It may well be more important that it be resolved in a single, coherent, intellectual product that everybody points out their nuanced disagreements.
Thank you. Ricardo.
Well, we came to the dissenting issue. Well, a lot of things to say. First, it should also begin with taking a look on the applicable law or the rules, because usually dissenting opinions are allowed, but when they are not, you have a problem, because if one of the members cannot agree on the award, you have the tribunal might reach a point where no decision will be rendered, because we three have to sign it, and I'm not comfortable with it. So we can really discuss it when we are talking about rules and laws that allows dissenting opinions, such as the Brazilian one. So I'm very used to, I think, when I think about dissenting opinions, I think it's very natural, it makes sense, and in a way, I disagree with Donald. I agree that it's preferable that we have unanimous decision, but for me, it's no big deal if you have a dissenting opinion, and from my point of view, from an arbitrator point of view, you should write your dissenting opinion if you don't agree with the majority. And in a way, it makes the decision better, because when the majority group knows that there's going to be a dissenting written vote, it helps to higher the quality of both decisions, because in a way there is a dispute of arguments inside the tribunal. I consider these facts differently, the legal consequence differently, and I higher the bar in a way for the majority vote as well. And I think as an arbitrator, arbitrators usually, despite the fact that they want to be appointed again, they should never be concerned about who's going to be happy or sad when the decision comes. This is something that should not be in the concerns of the arbitrator when deciding. You decide the case, you don't decide A or B, or it's not relevant who are the lawyers. I think it might be, there might be some paradox here, but the way you keep working in the field is directly related to your, that you cannot be that attached to the work, because otherwise you will end up doing things that Filipa said. You think on short term and you forget about your long-term career. Well, it's also said that when you have a dissenting opinion, and I'm finishing, Jack, there is a concern that someone might do that to show to the party who appointed it that he decided on behalf of their party. But as Professor Redfern says in one of his writings, it might also show that you were not able to convince the other group that you were right. So it really doesn't show a proficiency. It really doesn't show that you worked on behalf of the one who appointed you, but it might show that you were not as efficient as you were expected to be. So this is not something that the dissenting opinion shows, actually. It's more related, in my opinion, to what really is the concern about the arbitrator and what he accepts or not in the majority decision.
Thank you. Filipa.
So 3 hopefully quick points, lest I overstay my welcome. One is about rules. So as a lawyer, I discuss rules. As an arbitrator, I apply rules, but I don't get to make rules. But if I did get to make rules, there have to be compelling evidence for me to ban dissenting opinions, because I do think that they sometimes may have some pernicious effects, but they do, especially investment arbitration, sometimes advance legal doctrine, and they can also help tribunals reach better decisions. Because, as you were saying before, sometimes something did not write, but sometimes if you write it, a dissenting opinion, you may be more persuasive to your colleagues, and maybe you can each other either join the majority or change the majority. So there's also that. The other thing is that although the differences that you mentioned between investment and commercial arbitration are completely correct, I think that we're seeing a shift where commercial arbitration is getting more transparent. So awards are now will be published by the ICC. This is one of the incentives for proper behavior of arbitrators that I was talking about. And there's also contracts get more and more the same. So you have a lot of FIDIC contracts and things where you could actually benefit from seeing how other tribunals have decided certain issues that have more to do with the contract than with whatever law was applicable. So in that sense, whatever benefits dissenting opinions may have in investment arbitration, they may also have the same benefits in commercial arbitration. And to your point about splitting the baby, so there's a Roman general, Vegetius, that said that if you want peace, prepare to war. And I think that as a chair, it should be clear from the outset that you want to work in a united and cohesive tribunal, and that you are willing and available to listen to the opinions of your co-arbitrators, provided that they are independent and impartial. But it should also be clear that you are not afraid of, if necessary, render a majority award, or even, in extreme cases, your own award against the other arbitrators. Because this will also help the arbitrators to know what they can count on from you and make the whole tribunal less prone to guerrilla tactics from the other arbitrators.
Can I add 30 seconds? I promise it's just 30. The other thing, and I totally agree with Donald's point on the balance in the value of us speaking as a whole, to the value of at times, the negative point of making a compromise. The other point you need to think about also as a tribunal is the time it takes to get all 3 of you to be willing to speak as a whole. And there are times when actually it's more important to get the award out quickly on a majority if it's going to take too much time to get as a whole. It doesn't often happen, but there are times when that's so.
Good. Yes.
I think it's fair to say that anybody contemplating appointing a co-arbitrator or considering consenting to the appointment of a particular presiding arbitrator does as much as you can to find out about that person. Remember that the presiding arbitrator will frequently be, or most typically, appointed second, so you're not really taking that into account. although there are circumstances in which somebody may have to resign and then you have that circumstance. But I wouldn't want to be misunderstood about what you're taking into account. I think you'd be pretty foolish to say, well, she's a good buddy of his, and they do this, that, or the nothing that would reach the threshold of the IBA rules. At the end of the day, I think the most effective arbitrators are people who know what they're talking about and do the work. And I think that those are the folks who have influence within a tribunal. You may think of this as just a little bit, pie in the sky, but that's what you're looking for. You're looking for people who are both going to be independent and be perceived to be independent, who are going to be able to get the work done, and who are going to be able to, if you have persuaded them or their colleagues, for them to have an influence on the tribunal. So I think, there is, and people complain about it, there is this group of people, all of us who are, who both practice and advocate and sit. But people know who, as I say, know what they're talking about and do the work. And that, at the end of the day, should be the criteria we care about.
I think one last question up there. Well, I think it really then turns all the discussion that we've had will be a discussion about who does the algorithm.
Precisely.
Exactly.
And Donald and I will have may have one approach, and they may have another approach, and then the machine will work. But I think I think we should. I think there are limits to it, and particularly when the parties are choosing. Now, I think in this country, the only place that they're thinking of having that sort of decision-making process is in very low-value
Traffic tickets.
but consumer problems, but always with the right of appeal to a human. See, at my age, I'm perhaps more suspicious about this because I'm less adaptable. What other thing?
The only thing I'd add is exactly your point on who devises the algorithms, because the research coming out now on a number of other areas of artificial intelligence is that, and again, I'm sorry, this is stereotyping, but when it's a male or a team of men that are putting together the algorithms, doing the programming, you come out with very different results from when you have a diverse group of people preparing the algorithms. And all that happens is that you embed in the algorithm the subconscious bias that the individual has.
Any other points?
Agreed.
Can I?
Yep.
Yeah. There are some research, and so far we shall all be in peace that our jobs are not going to be replaced by machines in the next few years, especially these ones, a complex decision-making of a complex commercial dispute with a lot of facts and so on. On the other hand, talking about the influences that a machine wouldn't have, there are researchers, for example, it's a very good question because I have the opportunity to talk about this research specifically. The same kind of decisions of facts, the judges, male or female, doesn't matter, who decided just after the break or being fed, they were more favorable to the claimants.
The blood sugar factor.
Then
The status quo.
right before lunch or in the end of the day. So we human beings are subject to a lot of influence, effects, and so on. We have our own bias, and just like the lady said here, a mixed tribunal would be, I think, much better than any other tribunal or any machine that we might think about, at least for the next decade or so.
But if I may just add a final point. So we were talking about dissents, and there are, for instance, there's a famous dissent that changed the way and became the dissent, the way we look at fair and legitimate expectations on fair and equitable treatment.
Yes.
How could a machine write that dissent if that arbitrator was creating the law. So, and now this is the standard. So I think I'm a lot into technology. I go to Web Summit every day, every year. But the thing is, every one of us, whatever we do, think, oh no, my profession can never be replaced by computers. And actually, most of professions can. It's just a matter of what is the cost of that. And I think that as we are now, there's the problem that the bias, you're just shifting the bias. You're just transferring the bias of who programs to the machine, and there are still things that are not sorted out. If you ask me, in 500 years, will machines decide cases? Perhaps they will. Perhaps they will also rule the world.
Well, I think that given the blood sugar factor that's been introduced by Ricardo, we should now adjourn and for coffee. We will start again. The next session starts at 11:30. I want to thank the panelists for being so lively. I'm sorry that I was so inefficient that I didn't get more of you to talk, but I did my best.
Andre and Filipa and João for the invitation.
But we have
From all of us,
we have to thank everybody for the invitation, and this is the beginning of what I hope will be a very exciting day.